Mr. Justice McReynolds delivered the opinion of the court. An indictment in the District Court, Western District, Arkansas, charged that Jack Miller and Frank Layton did unlawfully, knowingly, willfully, and feloniously transport in interstate commerce from the town of Claremore in the state of Oklahoma to the town of Siloam Springs in the state of Arkansas, a certain firearm, to wit, a double-barrel 12-gauge Stevens shotgun having a barrel less than 18 in length, bearing identification number 76230, said defendants, at the time of so transporting said firearm in interstate commerce, as aforesaid, not having registered said firearm as required by Section 1130 of Title 26 United States Code, Act of June 26, 1934, c. 737, Section 4, subsection 5, 48 Statute 1237, and not in their possession a stamp affixed written order for said firearm as provided by Section 1130 Title 2 United States Code, June 26, 1934, c. 737 Sec. 4, 48 Stat. 1237, and the regulations issued under authority of the said Act of Congress known as the National Firearms Act approved June 26, 1934, contrary to the form of the statute. Such case made and provided in against the peace and dignity of the United States. Footnote 1, page 307 U.S. 176. A Yulee interposed demur alleged, the National Firearms Act is not a revenue measure but an attempt to usurp police power reserved to the states and is therefore unconstitutional. Also, it offends the inhibition of the Second Amendment to the Constitution, a well-regulated militia being necessary to the security of a free state. The right of people to keep and bear arms shall not be infringed. Page 307 U.S. 177. The District Court held that Section 11 of the Act violates the Second Amendment. It accordingly sustained the demurrer and quashed the indictment. The cause is here by direct appeal. Considering Sinzinski v. United States 1937, 300 U.S. 506, 300 U.S. 513, and what was ruled in sundry causes arising, page 307 U.S. 178 under the Harrison Narcotic Act. Footnote 2, United States v. Jinfui Moy, 1916, 241 U.S. 394, United States v. Dormus, 1919, 249 U.S. 86, 249 U.S. 94, Alinder v. United States, 1925, 268 U.S. 5, Alston v. United States, 1927, 274 U.S. 289 and Negro v. United States, 1928, 276 U.S. 332. The objection that the Act usurps police power reserved to the states is plainly untenable. In the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument, or is not within judicial notice that this weapon is any part of the ordinary military equipment, or that its use could contribute to the common defense. Imet v. State 2 Humphreys 10, 154, 158. The Constitution, as originally adopted, granted to the Congress power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections and repel invasions, to provide for organizing, arming, and disciplining a militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to discipline prescribed by Congress, with obvious purpose to assure the continuation and render possible the effectiveness of such forces. The declaration and guarantee of the Second Amendment were made. It must be interpreted and applied with that end in view. The militia which the states were expected to maintain and train is set in contrast with troops which they, page 307 U.S. 179, were forbidden to keep without the consent of Congress. The sentiment of the time strongly disfavored standing armies. The common view was that adequate defense of country and laws could be secured through the militia, civilians primarily, soldiers on occasion. The signification attributed to the term militia appears from the debates in the convention, the history and legislation of colonies and states, and the writings of approved commentators. Plainly enough that the militia comprised all males physically capable of acting in concert for the common defense, a body of citizens enrolled for military discipline, and further, ordinarily, when called for service, these men were expected to appear bearing arms supplied by themselves and of the kind in common use at the time. Blackstone's Commentaries, Volume 2, Chapter 13, page 409 points out that King Alfred first settled a national militia in this kingdom and traces the subsequent development in use of such forces. Adam Smith's Wealth of Nations, Book 5, Chapter 1, contains an extended account of the militia. It is there said, men of republican principles have been jealous of. A standing army has dangerous to liberty. In a militia, the character of the laborer, artificer, or tradesman predominates over that of the soldier. In a standing army, that of the soldier predominates over every other character, and in this distinction seems to consist the essential difference between those two different species of military force. The American colonies in the 17th century, Osgood, Volume 1, Chapter 13, affirms in reference to the early system of defense in New England, in all colonies, as in England, the militia system was based on the principle of the assize of arms. This implied the general obligation of all adult male inhabitants to possess arms, and with certain exceptions to page 307 U.S. 180 cooperate in the work of defense. The possession of arms also implied the possession of ammunition, and the authorities paid quite as much attention to the latter as to the former. A year later, 1632, it was ordered that any single man who had not furnished himself with arms might be put out to service, and this became a permanent part of the legislation of the colony Massachusetts. Also, clauses intended to ensure the possession of arms and ammunition by all who were subject to military service appear in all the important enactments concerning military affairs. Fines were the penalty for delinquency, whether of towns or individuals. According to the usage of the times, the infantry of Massachusetts consisted of pikemen and musketeers. The law, as enacted in 1649 and thereafter, provided that each of the former should be armed with a pike corselet, headpiece, sword, and knapsack. The musketeer should carry a good fixed musket, not under bast or musket bore, not less than 3 feet 9 inches, nor more than 4 feet 3 inches in length, a priming wire, scour, and mold. Sword rest, bandoliers, 1 pound of powder, 20 bullets, and 2 fathoms of match. The law also required that 2/3 of each company should be musketeers. The General Court of Massachusetts, January Session 1784, provided for the organization and government of the militia. It directed that the trained band should contain all able-bodied men from 16 to 40 years of age, and the alarm list all other men under 60 years of age. Also, that every non-commissioned officer and private soldier of the said militia not under the control of parents, masters, or guardians, and being of sufficient ability, therefore, in the judgment of the selectmen of the town in which he shall dwell, shall equip himself and be constantly provided with the good firearm, etc. By an act passed April 4, 1786, the New York legislature directed that every able-bodied male person, being page 107 U.S. 181, a citizen of this state or of any of the United States and residing in this state, except such persons as are hereinafter excepted and who are of the age of 16 and under the age of 45 years, shall by the captain or commanding officer of the beat in which such citizens shall reside within 4 months after the passing of this act be enrolled in the company of such beat. That every citizen so enrolled and notified shall, 3 months thereafter, provide himself at his own expense with a good musket or firelock, a sufficient bayonet, and belt, a pouch with a box therein, to contain not less than 24 cartridges suited to the bore of his musket or firelock, each cartridge containing a proper quantity of powder and ball, 2 spare flints, a blanket, and knapsack. The General Assembly of Virginia, October 1785, 12 Henning's statutes, declared, "The defense and safety of the Commonwealth depend upon having its citizens properly armed and taught the knowledge of military duty." It further provided for organization and control of the militia, and directed that all free male persons between the ages of 18 and 50 years, with certain exceptions, shall be enrolled or formed into companies. There shall be a private muster of every company once in 2 months. Also that every officer and soldier shall appear at his respective muster field on the day appointed by 11 o'clock in the forenoon, armed, equipped, and accoutrements as follows. Every non-commissioned officer and private with a good clean musket carrying an ounce ball, and 3 feet 8 inches long in the barrel, with a good bayonet, an iron ramrod well fitted thereto, a cartridge box properly made to contain and secure 20 cartridges fitted to his musket, a good knapsack and canteen, and moreover, each non-commissioned officer and private shall have at every muster 1 pound of good page 307 U.S. 182 powder and 4 pounds of lead, including 20 blind cartridges, and each sergeant shall have a pair of molds fit to cast balls for their respective companies, to be purchased by the commanding officer out of the moneys arising on delinquencies, provided that the militia of the counties westward of the Blue Ridge and the counties below adjoining thereto shall not be obliged to be armed with muskets, but may have good rifles with proper accoutrements in lieu thereof. And every of the said officers, non-commissioned officers, and privates shall constantly keep the aforesaid arms, accoutrements, and ammunition ready to be produced whenever called for by his commanding officer. If any private shall make it appear to the satisfaction of the court hereafter to be appointed for trying delinquencies under this act that he is so poor that he cannot purchase the arms herein required, such court shall cause them to be out of the money arising from delinquents. Most, if not all, of the states have adopted provisions touching the right to keep and bear arms. Differences in the language employed in these have naturally led to somewhat varying conclusions concerning the scope of the right guaranteed, but none of them seems to afford any material support for the challenged ruling of the court below. In the margin, some of the more important opinions and comments by writers are cited. Footnote 3, we are unable to accept the conclusion of the court below, and the challenged judgment must be reversed. The cause will be remanded for further proceedings.